Supplementary use for judgment, item number 1, CRA 4 1998.
In the result, the criminal appeal is allowed in part. The conviction of the appellants under section 302 by 149 IPC is altered to one under section 304 part 2 by 149 of IPC. And the sentence of imprisonment is reduced to the period already undergone. No separate sentence is awarded for the conviction of the appellants under section 147 and 148 of the Indian Penal Code.
I agree with the finding.
Because of this once I could not prepare me one day time.
That's right. Item 6.
Busy there the whole.
You have submitted.
They have
It
submitted
is already
earlier.
in record.
Yes, sir.
I may be pardoned, my lords, I am on virtual mode. Item number 8 for hearing. Can I pray? Taken up a week after because I am not well. That is my whole difficulty. Item 8, 1 week after, I am not well. Is a case 302 matter.
Please. Where is your note?
Yes.
They're on record. Along with the memo of citation.
Item 226. Item number 6. 8 of 256. Oh. 26 of 98. It was upon the consider. 8 upon the Supreme Court for judgment. And on the issue, no. What is this matter? I'm never with the corruption. Also. What is it? What a problem. Radhir Achi. Sure. Keeping it to next sitting, that is on
Tuesday.
26th. So you prepare it and give.
No, I have prepared one, but I'll cut that.
No, we cannot keep it tomorrow because
No, no.
this bench is not there. So let me go to the land council for the state. Six time to submit the written note of argument and memo of citations, if any. Land council for the appellant is present. Put up this matter on 26th. August 2020.
God bless you.
Okay.
Item number 2,
Two out of two, one has dead, one dead, two is alive. As reports on
How many appellants are there?
two,
Who are there? Krishna Mohan and
not dead, one.
Good day.
Who is dead?
No, appellant number one.
जरा लिखी दे appellant number 1 फिर आधे कर दे टूटा है कि तब आगे की तरफ next
Next time, only
Next
4 is
day.
dead.
Shadow, Purna dead.
Huh?
One,
That is only
one.
one.
A1
उल्टा कर दीजिए, Purna dead.
बाकी तीनटा अछंदी
हाँ तीन जन আছে।
A4 is dead.
से लिखी
नहीं ये one is
A1 is dead.
पूर्ण टाइम से चार रे दे दीजिए।
हाँ पुनः नंबर
A1 is dead.
that are the article there next week no? Partly a version. What's next?
item 4,
I probably review have the case. And keep NHA the file to review order. And then the
Item number 5.
go,
5.
no, 5 to go.
What are the something? What are the other? No. 5904. 2904 on the phone. Direction the opposite party more particular so on so.
Verify recent during that.
It is worth the compensation amount as expedition. Currently, even if we have 2 months from the date of production is the certified copy. They also be communicated to the petition wise one. But the communication triggered for what will look.
You are the petitioner?
Yes, yes.
Every communication for the
So Annex 2 series lots were along with postal tracking report.
That is received on 48 days.
They are the land acquisition officer and superintending engineer. You take instruction on all. I think it's if you are not challenging the order, then you have to comply it and otherwise you will issue notice soon. Take instruction. The contempt petition has been filed by the petitioner, Samrendra Kumar Mohanty. For passing the appropriate order under Contempt of Courts Act against the contemners opposite parties for non-compliance of the order dated 24/9/2024 passed in WPC number such and such. While disposing of the aforesaid writ petition, we hold as follows, quote paragraph number 6. Government has been taken in the contempt petition that the petitioner communicated the order of this court to the opposite party contemners on 21/2025 and 27/2025, which were duly received by the contemners and he has submitted the documentary proof in that respect as annexure 2 series. It is the contention of the land council for the petitioner that the complainants are not compliant with the order of this court. Land council takes some time to obtain instruction on this matter. Because this matter on 9th September 2024. Hello? Please copy of the order given under the word.
Item 5.
Yes, item 5, in other cases, there is some delay. But item I has issued notice on the limitation. My one friend has appeared for office number 1. That is a delay of 17 days. In second item, 23 days. Third item, 36 days.
My lord, I meant this. They have not served a copy read petition along with the limitation petition, my lord, not served, my lord.
Review petition.
I am appearing on behalf of a affected party of one, my lord.
Why you want read petition? It's a review petition.
No.
You want
Not
review
served.
petition copy.
Copy not served, review
Oh,
petition.
that you say, but you say
Along with the IA copy, my lord.
it's all right. You are appearing for the opposite
Number 1, in all cases, my
in
lord.
all cases. But you have not filed your power in
Filed
so many
already, filed,
items.
One case left.
Already filed, my lord, not reflected, my lord, minor.
In all the cases you have filed.
Filed, my lord.
All right.
Madam gonna ask you. Madam
So, allow an associate.
Madam gonna solve then as he is associate of
No, ठीक ଅଛି ସେ କହୁଛନ୍ତି ଯୋଉ ମାନେ let us see କାରଣ ସେ ଲୋକ ଗୁଡାକ ସବୁ ଅଲଗା ଅଲଗା ଲୋକ
Yes.
opposite party number 1 are you sure
My lord.
ମାନେ opposite party number 1 in review petition 298 of 24 is different than 282, different than 293. So you mean to say that in all the cases you have appeared entered appearance?
My lord.
देखो केबे फाइल कले दी वकालतनामा
2 weeks before, my lord.
आउ ए कोनोसी रिव्यू पिटिशन ने आपण कॉपी पाई नांती
My lord, one accept this.
एक्सेप्ट दिस माने कोटा 298
298.
लेखंदु व्हाट इज योर गुड नेम
Kirtan Badhi.
कीर्तन बढ़ई प्लीज गिव योर मिस्टर कीर्तन बढ़ई एटा प्रथम ता ऑर्डर कर दे 298 of 2024 लैंड काउंसिल opposite party number 1 na? Opposite party number 1 submits that though in this matter he has received the copy of the review petition, so also the interim application for condonation of delay, but in the connected matters, even though he has entered appearance for the respective opposite parties, he has not been served with the copy of the review petition, so also the copy of the interim application filed for condonation of delay. Mr. Mahanti, Land Council, appearing for the petitioner in all the review petition, submits that we will supply the copy of the review petition along with the interim application for condonation of delay on the Land Council for the opposite party number 1 by next week. By next week, put up this matter in the week commencing. Week commencing 16th of September 2025.
Lordship in sub-item 1 and 11.
ଏଗୁଡ଼ା କହୁଛନ୍ତି ସବୁଥିରେ ସେ ଅପୋଜିଟ୍ ପାର୍ଟି ନମ୍ବର 1 ପାଇଁ appear କରି ଯାଇଛନ୍ତି
6-7 जो 8
ସବୁଥିରେ
Private party notice.
So you are only for one
My lord.
in all cases.
That is the repetition, my lord.
So only for opposite part number 1.
My
ଅପୋଜିଟ୍ ପାର୍ଟି
One.
ସବୁଥିରେ
Lordship in
Well, kindly see order at 25 for 25. In that order.
It's all right, we are recording your statement, so लिख ले opposite
Lordship
party
in
number 1 in all the cases.
Sub item 1 or 11 रे आमे OP7 by my appearance to be marked.
Please wait, have patience. Look on the place the Wakalatnama of the filed by the Land and Council for the opposite party number 1 on record, and the name of the Land and Council for the opposite party number 1 shall be reflected in the cause list henceforth. Matter of recognition, so that you know, objection if any to the delay condonation application be filed in the meantime. Yes, you are appearing for
OP7 Lordship in
Yes,
sub
sir.
item 1 and 11.
Opposite party number 7 means one Kishore Kumar Panda.
Lordship.
अच्छा एटार आपण फास्ट आर अपीयर करछंती 298 रे ओपी 7 पाइन आउ कोथरे आपण अपीयर करछंती
11 रे sub item 11.
सब आइटम 11 माने ना ये
ये नंबर केते
Review petition number 16 of 25. 16 of 20.
हां 6
16 16 Lordship.
16 ने कहा पई अपीयर करछंती
ସେଥିରେ OP7 किशोर कुमार पंडा.
सही कुछ
अच्छा सर ओपी 7 वकालतनामा फाइल कर सारलेनी
Lordship.
वकालतनामा कहा ना रे अछि कोंतु मेन फर्स्ट काउंसिल
सरोज कुमार पाढ़ी आमर कोच लिस्ट रे नाटा भी आसी Lordship.
सरोज कुमार उधर ना आसी बोली कहउछंती
दिटा ना
कोथरे आपण ना रिफ्लेक्ट हेजी
कोच लिस्ट रे Lordship.
और लिस्ट ना ये सब तो अपीयर करना बहुत
MS सरोज कुमार पाढ़ी अछि.
16 रे अछि बाकी एथरे
फास्ट आइटम रे अछि
फर्स्ट आइटम तो अछि
298 by 24 रे
हां हां ताले कोन आपण चाहुचंदी कोन
Lordship, we are the recorded tenant of that land, Lordship.
we are not hearing on Mary problem. Have you filed any objection to the delay condonation application?
No, Lordship.
You
We
don't
have
want to
no
file?
objection.
Okay, you have no objection. All right. खाली लिखि दियंतु दीटा आइटम रे 298 आउ 16 रे the Land and Council for the opposite party number 7 is present. एतु को छाड़ है ना हां कोडा सब गुडा करिवे देखो अपन जेम सुविधा हो
नहीं जदी अपोजिट पार्टी गोटे हिते ता तो ठीक है भला असुविधा
थाक थाक करी प्रथम टारे यदि थाक थाक करी लिखि देबे दे देबे ऑपोजिट पार्टी नंबर 7 इन
रिव्यू पिटिशन
गोटे ऑर्डर तो अननेसेसरी तो बड़ी दरकार नहीं यस
Okay.
अच्छा वो 16 तारीख है ना 16 9 2020 यस
Item 7.
26 तारीख है ना
16
नहीं जो 6 नंबर टा
26
26 8 ये 7 मिस महापात्र
एटा दुई जन जाक तो लाइव
subject stands submitted against appellant number 2 लिखा है
आगुरु
और अब ये केते जण appellant अंदर अछंदी 2 जण
दुई जन
लिंगू alias
Counsel.
Counsel आपे आगुरु 2 in slow अच्छा that is 14825 हां आरटा लिखा है staying with his family members Lingu is staying with his family members and his Bisma बराबर दीपाली महापात्र ये कत तारीख थिले
ना लास्ट टाइम
Can you give him a ring? Can you give her a ring so that if he is not interested, we can engage somebody from that list which we have recently received from the High Court Bar Association.
I'll call.
The persons who are having 10 years of practice and interested, the list has been supplied to us. So that is available. We are actually serially we are engaging in all the jail criminal appeals one by one. So please ask her if she comes.
Just give it. 8 report has come.
Kodre?
8.
8 Mr. Satyadhar Das made a mention that he is not well,
The
but
report has come
what is that report?
except Ghatsiram is aware of normal or Ali.
Ghatsiram is dead. So any order has been passed in respect of Ghatsiram? No order.
No.
No order has been passed, brothers. No order has been done. Your brothers, appellant number 1 has now undergone the sentence and has been released. So for 2, 3, 4, the bail was rejected. 1 is now dead, and then 2 and 4 are alive.
Undergone sentence means Mr. Das, whether he has not been sentenced to life imprisonment.
Yes, I think he has now been released after.
Prematurely.
Yes, that is my. Nobody is contacting, but no, I think the note sheet shows that. That is my understanding.
But we have received this report from in which it is mentioned
Millers.
that Rupa Jorai, kete number Rupa Jorai?
1, he is 1.
Achha, Rupa Jorai was released from jail and now he is present in his house. Okay. Accused persons Bharat, Rupa Jorai gala A1. Okay. Then Bharat alias Krishna means A2. Then Jagomohan Jorai gala A4. Are now present in their houses at Katha, Bharia. Both the accused,
No, but the accused
Ghasiram Jari,
3.
so and so, has absconded since and is not known. তাহলে মরিগলা বলি কোড কইছেন
মরিগলেন
ও
absconder is whereabouts.
absconded so update কিছু করিব না
No,
they have been released on bail so let him go there but once the result of the case ultimately demands that then he will be so that means it will continue for all the appellants.
I think appellant number 1 has been released after undergoing the sentence.
Okay. But no, that is the report is that he has been released from jail, but it is not mentioned that premature release and whether this court has granted him bail or
No. His bail was rejected.
16/12/2000 ରିଜେକ୍ଟ ହେଇଥିଲା ଅନ୍ୟ 3 ଜଣଙ୍କର ଆଲାଉ ହେଇଥିଲା
ଅନ୍ୟ 3 ଜଣ ବେଲ୍ ପାଇଥିଲେ his bail was rejected.
2 କୁ 4 bail ଦିଆ ହେଲା
ଆଜ୍ଞା
एकटाକୁ ରିଜେକ୍ଟ ହେଇଛି right
ଆଜ୍ଞା
तो ସେଇ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ନେଇ ଆସୁନାହାନ୍ତି ହେଲା ଯଦି ପ୍ରିମାଚ୍ୟୁର ରିଲିଜ ହେଇଥିବ କାରଣ ବେଲ୍ ତ ଦିଆ ହେଇନି ନା ତାକୁ hard Mr. Satyadhar Das and senior advocate appearing for the appellants. Mr. Mahanti, land counsel appearing for the state has produced the written instruction received from officer in charge of Badam Pahad police station dated 14/8/2025 from which it reveals that the appellant number 1 has been released from jail and is present in his house. Appellant number 1, similarly appellant number 2, so and so, and appellant number 4, they are present in their house at Katha, Bharia. So far as appellant number 3, Ghasiram Jare is concerned, he has absconded since 2003 and his whereabouts is not known. Stop. From the order dated 16/12/2002, it appears that while rejecting the bail application of appellant number 1, Rupa Jari, the other 3 appellants were directed to be released on bail. Stop. of Paragana. Mr. Das, land senior advocate, submits that he has instruction that perhaps appellant number 1 has been released prematurely. And that is how he is now available in his village, even though he has not been released on bail by this court. Stop. Land counsel for the state seeks some time to obtain instruction from the concerned jail authority in that respect. So, stop. Mr. Das also an adjournment on his illness ground, put up this matter on. So it can be brought on 9th of also. Thipo the order Nishan Thipo jail premature release order 9th of September 2025. Free copy of the order to hand it over to the land council for this case.
Item 7.
Item 7, huh?
Yes, I have contacted Ms. Nipal Mapatra. He has stated that he can engage any legal aid counsel because that brief initially was interested justice on that. Thereafter, when he elected, that brief has come to the Mahapatra. Now they are not contacted, so
The list of the answer. Achhi hai, I don't know. For Kojo they condition next time paper book area. Paper book achhi to supply for they can not side to go to phone le bhi hum phone mein kuch ha contact least row. For a competitive rotation very well.
I will go back.
Yes. It লেখি দেবেন Miss Dipali Mahapatra, when the matter was called, Miss Dipali Mahapatra was not present in court. The land additional government advocate, Mr. Nayak, was asked to contact Miss Dipali Mahapatra. Accordingly, he contacted Ms. Mahapatra to state that some other counsel from the High Court Legal Services Authority may be engaged as he is not interested to argue the matter. According to this one, so it's not a copy of paper which we supplied to him. And it may also be intimated that the matter is listed on 9th of September 2025 for the year. Yes. कितना नंबर आपने करा?
54 my lord may be taken.
50. Okay, your application was rejected for repeat well and see. And we will request. Find out from the date you want to. Toll appellant to?
My lord.
अच्छा 24/3/2011 में 24/3/2011 में अब पेपर बुक टा मगेई दियंतु अछि आई विटनेस अछंती
No, my lord, there is no direct eyewitness, man. Eyewitness na.
आई विटनेस में ओ आपण एफआईआर पढ़िले फाइल सही था
Mine.
पढ़ंतु एफआईआर टा पढ़
My lord. माननीय श्रीयुक्त सदर थाना भारप्राप्त अधिकारी ढेंकानाल ମୁଁ ଶ୍ରୀ ଦଣ୍ଡପାଣି ବେହେରା
दंडपाणी बेहरा केते नंबर साक्षी
ଦଣ୍ଡପାଣି ବେହେରା ମାଇ ଲର୍ଡ ଏଇଟା ହଉଛି ଇନଫର୍ମାଣ୍ଟ PW14 ମାଇ ଲର୍ଡ
ओ पढ़ंतु डिसीज रो ना कोन
TCD ନାଁ ହଉଛି ପିଣ୍ଟୁ ଆଲିଆସ ପ୍ରିୟବ୍ରତମ
इनटू alias कोन पुराना टा कोन
ମାଇ ଲର୍ଡ ପତି ପ୍ରିୟବ୍ରତ ପତି ମାଇ ଲର୍ଡ
अच्छा प्रिय वर्ष को ओ पळे आछन एफआईआर पढ़ंतु
ମାଇ ଲର୍ଡ ଦଣ୍ଡପାଣି ବେହେରା ବୟସ 24 ପିତା ଟିମା ବେହେରା ଉଞ୍ଚୁବରୀ थाना सदर जिला ढेंकानाल आद्यता 23/3/2011 अपराह्न 3:30 समय कंवरपुर ग्राम निकटवर्ती रगड़ा निकटरे आपनको एहिकी लिखित रिपोर्ट करुअछि कि आज मु एवं इंदुपुर ग्रामर सुशांत पृष्टि जीतू साहू बाबुली साहू निशाकर प्रधान चेंक बेरईर सुनाखाई नाल पाखरे भेटी करुथिलु दिन प्राय 12:30 समय दुईटी पिला कंवरपुर ग्राम पटे चाली चाली जाइथिले प्राय अपराह्न 2:30 समय सही दुई जनक मध्यरु जने फेरिबार देखिबाकू पाइलु उक्त पिला को पचारिबारु उक्त पचारिबा समय अन्य पिला
बाबदरे
आज्ञा बाबदरे तार पैंट एवं
साठ संपूर्ण
आज्ञा सार्ट संपूर्ण रक्त रे भिजी जाइथिला देखि पाइलु ताकू पचारिबार कहबार से तार
पाइला देखि रपे
आज्ञा
देखिबा तार भिजी जाइथिला बोली देखिया को पाइलु
रक्त रे भिजी जाइथिबा देखिया को पाइलु पैंट सार्ट तार
हां
पाइलु ताकू पचारिबारु
पचरा उचरा
करिबारे से तार नाम करुणा बेहेरा पिता सनातन बेहेरा चित्तपुर ग्राम बोली प्रकाश करिथिला अन्य पिलाटी कुआडे गला बोली पूर्णतार पचारिबारे से ताकू गोटे छुरी द्वारा बेक काटी मारी मुंडिया उपरे देई आसीछि एवं से पिलार नाम पिंटू ओरफ प्रियव्रत पति पिता पवित्र मोहन पति बोली कहिथिला आम्भे माने ता कथा बानरे इंदुपुर ग्राम कुंज भाई को पचारिलु कुंज भाई को कहिबा अनुसार आम्भे माने वरुण बेहेरा को आम पाखरे अटक रखिथिलु
करुणा बेहरा ना
वरुण बेहेरा को आम पाखरे अटक रखिथिलु पुंजी तार आसीबा परे आम्भे माने वरुण को सेई मुंडिया पाखकू मुंडिया ऊपर को नहीं वरुण देखाइबारे सेठारे पिंटू मृतदेह पड़िछि 75 भाग पोड़ी हुई गोटे लिंब गछ मूले फूल मध्य मुदी हुई पड़ी पाइथिलु पिंटूर बेकरे गभीर क्षत चिन्ह थिबार देखिथिलु आज को एतुक आसिया ठारे ପଞ୍ଜୁ ଭାଇ ଥାନାକୁ ଫୋନ କରି ଏହି ହତ୍ୟା କହିବାରେ ତାଙ୍କୁ ମୋବାଇଲରୁ ଜଣାଇଥିଲେ। ଆପଣ ଘଟଣାସ୍ଥଳରେ ପହଞ୍ଚି ମୋର ଲିଖିତ ରିପୋର୍ଟ ସହିତ ବରୁଣ ବେହେରାଙ୍କ ବିହିତ କାର୍ଯ୍ୟ ଅନୁଷ୍ଠାନ ପାଇଁ ଜଣାଉଅଛି। ଇତି ଆପଣଙ୍କର ବିଶ୍ୱସ୍ତ ଦଣ୍ଡପାଣି।
ଆଚ୍ଛା, ଏଇ ଯୋଉ ଲୋକମାନେ ଆ ପାଖରେ ଥିଲେ, ପାଖରେ ଥିଲେ, ତାଙ୍କ ଭିତରୁ କିଏ ଏକ୍ସାମିନ ହେଇଛନ୍ତି? ଅର୍ଥାତ୍ 4-5 ଲାଇନ ତଳକୁ ପଢନ୍ତୁ। ସୁଶାନ୍ତ ପୃଷ୍ଟି ଏକ୍ସାମିନ ହେଇଛି?
ସୁଶାନ୍ତ ପୃଷ୍ଟି,
ଯୋଉମାନଙ୍କ ପାଖରେ ସେ ଭୋଜି କରୁଥିଲା ସାଙ୍ଗରେ, କହୁନି ଉପରେ?
ଆଜ୍ଞା ତିରୁବନନ୍ତପୁରମ ପ୍ରଧାନ
ନା,
ଡ୍ରାଇଭର
ହେଇନି।
କେହି ହେଇନାହାନ୍ତି।
ସୁଶାନ୍ତ ପୃଷ୍ଟି ହେଇନି। ଜିତୁ ସାହୁ ଦେଖିନି କୁହନ୍ତୁ ଠିକ ସେ।
नो माइनर।
ନା, ଜିତୁ ଆସିଥିଲେ, ଜିତେନ୍ଦ୍ର PW10।
ହେଇଛି ଆଉ ମନା କରୁଛନ୍ତି। ଜିତୁ ସାହୁ ହେଇଛି। ହଁ
जितेंद्र कुमार साहू नो एडवर्स ओपिनियन PW10 माइन।
ହଁ ଆମେ ପଚାରୁ ହେଇଛି ନା।
आज्ञा आज्ञा PW10
ବାବୁଲି ସାହୁ
PW11।
ଆଚ୍ଛା, ବାକି ନିଶାକର ପ୍ରଧାନ
ନିଶାକର 7।
PW7 ଅଛି। ତାହେଲେ ଏଇ ଯୋଉ FIR ପଢିଲା ପରେ ଦିଟା ଜିନିଷ ଆପଣଙ୍କର ଇଏରେ ଆସୁଛି। ଗୋଟେ ହଉଛି ଲାଷ୍ଟ ସିନ୍, ଆଉ ଗୋଟେ ହଉଛି ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ। ବର୍ତ୍ତମାନ ପଳେଇ ଆସନ୍ତୁ ଆପଣଙ୍କର ଚାର୍ଜ କୁ ଆସନ୍ତୁ, पेज नंबर 50 को आसନ୍ତୁ।
माइनर charge with charges with 2 heads minor 50 minor।
हाँ, ऊपर चार्ज ହେଇଛି, କଣ ପାଇଁ ଚାର୍ଜ ହେଇଛି?
श्री MM Mahanti LLB session figure Dhankanath. First, that you on 23 March 2011 in between 12:30 PM to 12 PM Kanpur Hill did commit murder by intentionally causing the death of a Priyabrata Pati alias Pintu and thereby committed an offence punishable under section 302 of Indian Penal Code and within my cognizance. Second, my brother, you on the above noted date, time and place, in knowing that certain offence murder punishable with death has been committed by you, did cause certain evidence of the said offence to disappear, concealed the dead body Priyabrata Pati alias Pintu after committing his murder hurriedly under a neem tree in a stone beach with the intention of screening yourself from legal punishment and thereby committed an offence under section 201 IPC and within my cognizance.
Okay, so what are the circumstances? Has it been jotted down anywhere in the impugned judgment that these are the circumstances against the appellant? Para 7
Circumstance number I.
para 7 रे अछि। एतिके सब paragraph 7 को पढ़े आसुन।
Minor.
Page number internal 8 ना 8 was 8. Running page 10, internal page 8. पढ़ो।
Page 8 minor.
हाँ, internal page 8 but running page is 10, paragraph number 7. Coming to the complicity. File. Para 7.
Minor.
पढ़ो।
Coming to the complicity of the accused in the commission of the crime, the prosecution relies on various circumstances. Admittedly, there is no direct in the shape of a narration of the eyewitness in this case, and the prosecution mainly relies on the following circumstances to prove its case. Homicide nature of death of the deceased. The accused had prior acquaintance with the deceased as there was friendship between them, and the accused had taken a loan of 10,000 from the deceased. Third, my lord, on the morning, the date of occurrence, the accused had been to the house of the deceased and called the deceased to give with him
To go with him, huh?
deceased
Doctor can-
go with him.
Ah.
Go with him to the house of his aunt for payment of the loan, and both of them left the house of the deceased together. On the same day, at about 12:30 p.m., the accused and the deceased were last seen going together towards Kanpur Hill. On the same day, at about 2:30 p.m., the accused was seen alone returning back, having covered his face by a Turkish towel with blood-stained cloth and having an airbag. The accused made an extrajudicial confession before PW 7, 10, 11 and 14.
ये सब भोजी वाला को
ये जो एमाने भोजी करते
हाँ ठीक है पढ़ो
and have murdered the accused and burnt his dead body, and he was detained by PW 7, 10, 11 and 14, and police was informed over telephone, and after arrival of the police, FIR was lodged. After arrest, the accused led the police and witnesses to the place of and gave recovery of the weapon of offense. The medical officer opined that the injury found on the deceased could be possible by such weapon of offense. The voter ID card, Nokia mobile phone and money purse containing cash of 220 belonging to
The deceased.
deceased were seized from the possession of the accused. Inside the injuries were found in the gap between right thumb and in finger and on the left index finger of the accused hand. The doctor opined that these type of injuries can be possible when someone attacks another by means of a sharp cutting weapon like a knife, and the other struggles for life and tries to escape from
His cloth.
his clutches.
अच्छा आज आ गोटे सर्कमस्टांस छाड़ देइचंती जे आपण को इंस्टेंस रे डेड बॉडी मध्ये रिकवरी होला
Say leading to discovery.
खाली माने वेपन ऑफ ऑफेंस ता देइचंती बट माने एफआईआर अनुଯାयी डेड बॉडी कोन देखैचंती लेकिन leading to discovery
Dead body as well as recovery of it.
एटा डेड बॉडीटा आपण एफआईआर लॉज हवा पूर्वरु देखैचंती बट रिकवरी देइचंती वेपन ऑफ ऑफेंस बोधवे पुलिस आसिला परे at the instance. Okay. So, prathame homicidal death, I think you have no dispute about that. Who is the doctor who conducted PW 13? PW 13 को पढ़े सुन.
PW 13 has no direct knowledge, but he came to from the discussion.
PW 13 is the doctor who conducted.
PW 5, PW 13 Dr. Pratap Das conducted the postmortem examination.
So anything you want to say, because the doctor has noticed that these are the injuries and he has opined that the cause of death was the throat injury caused by sharp cutting knife, so and so. So postmortem in nature and sufficient to cause death, and it is homicidal. And the burn injury also here thin and so on so. So hence in my opinion burn injuries were postmortem in nature. Mala par phodichanti taku. So that is there. Knife taku dekhin कहचंती injuries found on the dead body of the deceased might have been caused by knife MO2, and injury to the neck is sufficient in ordinary course of nature to cause death. Report देइछन exhibit 10. So PM report हला 9, opinion report हला 10. छोटा blood sample also once collect करचंती. So nothing has been elicited in the cross examination. So homicidal death. गला तापरे next टा आसंतु. Circumstance number 2. As for the accused had prior acquaintance with the deceased and there was friendship between them. Accused had taken loan of rupees 10,000. A circumstance whose discussed each. Acha, you come to paragraph number 11. of the trial court judgment. Internal page 11, paragraph number 11.
No. Minor.
ଆପଣଙ୍କର ଆଉ
Minor, to prove this circumstance, the prosecution mainly relies on the evidence PW2, 12 and who are the sister and mother of the deceased respectively. PW12 has stated in her evidence that on 23/3/2011 in morning hour at 9 p.m. while she
9 a.m. morning.
ତଥ୍ୟ କାହିଁକି ହଉଛନ୍ତି? ହଁ 9 AM ସକାଳଟାକୁ ଆପଣ ରାତି କରିସାରିଲେଣି।
hour
23/3/2011 ସକାଳ 9ଟା ବେଳେ ପଢନ୍ତୁ।
again in morning hour at about 9 a.m. while she had her deceased
She
bro-
and her
Aye.
deceased brother.
while she and her deceased brother
Ah.
were in the house
Hmm.
at that time. The accused came to their house and called the deceased to accompany him to village Kunjari
Ah.
to the house of his aunt for a repayment of a loan of 10,000, which the accused had taken earlier from the deceased. And accordingly, the deceased went with the accused in her presence from their house. On the same day, at about 3:30 p.m., they got information that the accused had murdered the deceased at Kanpur Hillock and burnt his dead body. PW16 corroborates the evidence of PW2
12.
of 12
Hmm.
regarding going of the accused
To their house.
regarding going of the accused to their house on the morning of the occurrence day, and that the accused called her son to accompany him to the house of the aunt to repay the loan amount to 10,000, which he had taken earlier from the deceased, and both the deceased and accused left their house, and on the same day at about 4 p.m. she had that the accused had murdered the deceased at Kanpur Hillock and burnt his dead body. Both
12 and 16.
have specifically stated that the deceased and the accused were good friends. Railing on the evidence PW2, 12 and 16, the Lord and Public Prosecutor submitted that the accused had prior acquaintance with the deceased, and therefore the prosecution successfully proved the circumstances about the prior acquaintance of the accused with the deceased, as they were good friends, and the accused had taken a loan of 10,000 from the deceased.
ରହିଗଲେ କଣ?
In reply, the London SDC submitted that except the evidence of PW12 and 16, who were the relations of the deceased, there is no independent corroboration to their evidence that the accused and the deceased were good friends, and the accused had taken a loan of 10,000 from the deceased earlier. As such, their evidence is not acceptable. And analyzing the evidence of PW12 and 16, it is seen that both of them are related to the deceased, being the sister and the mother respectively. Both of them stated that the deceased and accused were good friends, and the accused had taken 10,000 earlier from the deceased, and on the date of occurrence, the accused had been to their house to call the deceased to return back the loan amount. In the cross-examination by defense, PW2 had
12. PW12 has.
minor. In the cross-examination by the defense, PW12 has clarified that the accused had taken the loan from the marriage
For
of
the marriage.
loan for the marriage of his sister, and PW16 stated that she had personal knowledge about the said loan. The defense fails to bring out anything from the mouth of these two witnesses as to why they stated falsely against the accused. Merely because of PW12 and 16 are related to the deceased as sister and mother respectively, their evidence cannot be thrown out
On the ground of interestedness.
Ground of interested witness. In this contest, I am the legal principle enumerated by the Honorable Apex Court in case number Samlal Ghosh versus State of West Bengal, reported in 2012.
Next, in the instant case.
Their Lordship held that no doubt.
In the instant case.
Paragraph in the instant case.
In the instant case, it is submitted that.
Admitted that.
It is admitted that both PW12 and 16 are close relations of the deceased. But there is nothing on record that these witnesses have any acts to grind against the accused. So also no motive has been attributed to them to implicate the accused falsely. Hence, in my consideration view, the evidence of PW12 and 16 do not suffer from any
interestedness.
And from their mouth, the prosecution successfully brought out that the accused had prior acquaintance with the deceased, being friends, and the accused had taken a loan of 10,000 from the deceased.
या फिर आपन कौन कहियार अछि ए जो सर्कमस्टेंस ता पडिले जे दुई जण साक्षी जे कि तार रिलेशन
ए दुई जण साक्षी होछन माय लॉर्ड ସେମାନେ କହୁଛନ୍ତି ଯେ ସେମାନେ ତା ପୁଅଙ୍କ ସବୁ ଭାଇ ସହିତ ପରିଚିତ ଏବଂ ସେମାନେ ସେ ଲୋନ ନେଇଛି ବୋଲିକି ସେମାନେ କହୁଛନ୍ତି।
ଖାଲି ସେତିକି କହୁନାହାନ୍ତି
ଆସିଲା ଡାକିଲା
ନେଇକି ଗଲା
ଟଙ୍କା ନେଇଯିବ ବୋଲି ତା ଆଣ୍ଟ ପାଖରୁ କହିଲା।
ଏଇଟା ଜିନିଷ ଆସୁଛି ମୋଟିଭ ଆଉ ଦ୍ୱିତୀୟ କଥା ହଉଛି ଲାଷ୍ଟ ସିନ୍। ଏଇ ଦି ଜଣଙ୍କ ଏଭିଡେନ୍ସ ତାର ଏଭିଡେନ୍ସ ଟାକୁ ଆପଣ କେମିତି ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି?
ଆଇ ଆମ୍ ଚ୍ୟାଲେଞ୍ଜିଂ। ସେ କହିଲା ଯେ ମୁଁ ଯିବି ଆଣ୍ଟ ଘରକୁ, ମୋଟିଭ ତାର ନାହିଁ ଟୁ ମର୍ଡର। ଦିସ୍ ଇଜ ନଟ୍ କ୍ଲିୟରଲି ଷ୍ଟେଟ୍ ତାର ମୋଟିଭ
କହିକି ନେଇଥାନ୍ତା ମୁଁ ଚାଲ ମର୍ଡର କରିବାକୁ।
ନାଇଁ ମୋଟିଭ ତାର ନାହିଁ, ବିକଜ ମୋଟିଭ ମାଇଣ୍ଡ ନୋ ଭେରି।
ସେ କହିଲା ଯେ ଚାଲ ଖୁଡି ଘରକୁ ଯିବା, ସେଇଠି ମୁଁ ତତେ 10,000 ଟଙ୍କା ଦେଇଦେବି। ଡାକିନି ତାକୁ ଡାକିକି ନେଇକି ଗଲା, ଆଉ ଡାକିକି ନେଇଗଲା ବେଳେ କଣ କହିଥାନ୍ତା ମୁଁ ଚାଲ ତତେ ସେ ପାହାଡ ଉପରେ ମର୍ଡର କରିବି? ସେ ଯାଇଥାନ୍ତା
ଛୁରୀଟାକୁ ଦେଖେଇଥାନ୍ତା ଯୋଉଟା ବ୍ୟାଗ ରଖିଥିଲା। ଛୁରୀଟା ଦେଖେଇଥାନ୍ତା ନା ତାକୁ କହିଥାନ୍ତା ମର୍ଡର କରିଦେବି? ଦିଟା କହିଥାନ୍ତା ଯାଇଥାନ୍ତା।
ସେ
କାହିଁକି ଦିଟା କାହିଁକି ଷ୍ଟେଟମେଣ୍ଟଟା ଏଇ ଗୋଟେ ପର୍ଟିକୁଲାର ସର୍କମଷ୍ଟାନ୍ସଟା ଆପଣଙ୍କର ଦିଟା ସାକ୍ଷୀଙ୍କର ଷ୍ଟେଟମେଣ୍ଟଟା କାହିଁକି ଡିସବିଲିଭ କରାଯିବ? ଆଗେ ଆ ଉପରେ ଆପଣଙ୍କର କମେଣ୍ଟସ କ'ଣ? ହ୍ୱାଟ ଇଜ ୟୋର ସବମିଶନ ଅନ୍ ଦିସ୍ ପଏଣ୍ଟ? Because only ground has been urged in the trial court that they are related witnesses and therefore the evidence should not be accepted. The learned trial court has said though that is not a ground to disbelieve the witness, and he has relied on a decision of the Honorable Supreme Court. And that is also the settled principle that merely on the ground of related witnesses, it cannot, particularly when the occurrence has happened in their house. He has come to the house of the deceased was present, and obviously the family members were present, and in their presence he was called and taken on the pretext of repayment of the loan amount of rupees 10,000. So why this evidence of these two witnesses would be disbelieved? What is your comments?
My lord, my comment before my lord is very thorough and well versed the law of motive. Motive, my lord, is the mind of the accused. And seldom be performed with any degree of accuracy. A jo motive ta my lord has categorically indicated. I say that he has no motive because he is the friend of the deceased. He said that I will repay the amount to go. Jodi se aunt घर को न गला ताले से जे तो हिल यार्ड को गला my lord. So the deceased may object why you are going to there.
ସେଠି କଣ ହେଇଛି କେହି ଜାଣିନାହାନ୍ତି। ସେ କାହିଁକି ତାକୁ କଣ କହିକି ହିଲ ଆଡକୁ ନେଲା, ଏଇଟା ତ ଡାଇରେକ୍ଟ ଏଭିଡେନ୍ସ କିଛି ନାହିଁ ନା, ସର୍କମଷ୍ଟାନ୍ସିଆଲ ଏଭିଡେନ୍ସ ଅଛି। ତାକୁ କହିକି ନେଲା ଯେ ଖୁଡି ଘରକୁ ଯିବା, ସିଏ ସେ ହିଲ ଆଡକୁ କାହିଁକି ଗଲା, सेठी केमती से दी जण पहुंचिले ए विषय तो किसी एविडेंस नहीं
नो माइलॉर्ड
तेणु जना पड़ो जे आपण ए दीटा एविडेंस ताकू कहीकि नहीं 10,000 टका देदेवी फुड़ी घर को गले से ये से जाइछि तापर किंतु फुड़ी घर को जाइनी एडमिटेडली तार डेड बॉडीटा एठी मिली आपण सांग थिले नॉट ओनली घर पाखे थिले बाट मझीरे मध्य आपन को आउ 4टा विटनेस जो माने भोजी करुथिले से माने मध्य देखछन्ती आमे आसीबा से एविडेंस डिस्कस करिवा कहूँ जे 12 आउ 16 जो माने कि तार डिसीज्ड घर मेंबर से माने जो स्टेटमेंट को कहीं ट्रायल कोर्ट जो बिलीव करछन्ती कहीं आमे डिसबिलीव करिवा सेही ऊपर आपनकर कोन सबमिशन अछि कोन
My submission, my lord. Admittedly, he has gone to his residence house. घर को तांका घर को जाइछि
यार घर को जाइनी
जाइछि
हां
एवं कहिछि जे हमें जिबा
so you that is your accused statement रे admit करछन्ती
ना एक्टिविटी स्टेटमेंट
कहिछन्ती
सब मना करछि
admitted माने कोन पूरा सब मिछ कथा कहिछि
आज्ञा
12 नंबर साक्षी रो स्टेटमेंट जेतेबेले पचरा हिची the question 12 आउ गेटे 16 क्वेश्चन नंबर केते मिस्टर महांती मिस्टर नायक मिस्टर महांती देखिले ए 12 नंबर हां एटी परा
12 नंबर 11
हां नहीं 1 नंबर क्वेश्चन डाउजी गुड फ्रेंड मिछ कथा तापरे
12 गली 12 and sold direct question transfer from the evidence to
केते नंबर क्वेश्चन डाउ
11
हां it transfers so and so that on the same day at about 3:30 to 4 they got in for नहीं এটা পর কথা এই जो ঘরু ডাকি নেইଥିଲା जो ताकू पचरा है तो क्वेश्चन जे
well question 22 is there 22 is 22
हां 12 16 रो साखीटा जो ताकू डाकी नेला घर
16
हां एटा आइटम नंबर 3 को पड़े आसु it transfer from the evidence that you called the deceased Pintu to go with you to return back money of rupees 10,000 which you had borrowed earlier from him and asked him to accompany to village so and so to the house and on your call he accompanied you एटी खाली ओमिट कर जाइछन्ती से दीटा साथी पचराई सर्कमस्टेंस तो पचराई खाली 12 और 16 ना कहिना कहा एविडेंस एटा ये करे बट मिछ कथा आ एडमिट कलो कोड कोन
नहीं एडमिट
अरे
मिछ
आपण जोटा कहउछन आपण कहले ना दैट इज एडमिटेड माने हम भाबलो दे अक्यूज्ड को अक्यूज्ड स्टेटमेंट रे एडमिट कर जाई so what are your comments again we are asking you what are your comments on PW evidence of PW 12 and 16
मतलब एविडेंस जेहेतु दे आर रिलेटेड एंड
ना देछि गोटे प्रकार काहे कि एक नंबर से कहला क्वेश्चन 1 हला it transfers from the evidence of PW to 16
or from the other level अच्छा ठीक है okay then it's right ठीक है that has been asked yes हां कौन
my lord has categorically indicated and pointed out transfer from evidence called deceased Pintu to go with you to return back the money 10 which you had borrowed earlier from him asked him to accompany village Kundachari सेथरे से कहज my lord it is false so he has never taken 10,000
तो सेटा हम एक्सेप्ट करियो अक्यूज जोटा कहिला इट इज फॉल्स बोली हम 12 और 16 को हम किछि विश्वास करबनी कारण अक्यूज मना कला
Again, my lord, when the 10,000 has been taken by the deceased accused, the 12 and 14 has not seen ତାଙ୍କ ପ୍ରେଜେନ୍ସରେ ଦିଆ ହେଇନି କି ସେ ଜାଣି ନାହାନ୍ତି।
କହୁଛନ୍ତି ପର୍ସନାଲ ନଲେଜ have you seen the evidence?
ଘରକୁ ଆସିଲା ଡାକିବ ଯିବ।
ନାଇଁ ସେମାନେ କହୁଛନ୍ତି ଆମର ପର୍ସନାଲ ନଲେଜ ଅଛି। You come to that PW 16 evidence ଆସନ୍ତୁ page 97 cross examination ଆପଣ ହିଁ ବାହାର କରିକି ଆଣିଛନ୍ତି paragraph 5 PW 16 page number 97 ହେଲା paragraph 5 cross examination second sentence.
I had
personal knowledge about the loan which was given by my deceased son.
I had about the murder of my son from the villagers. My deceased son was earning nothing. I have personal knowledge about the loan which was given by my deceased son to the accused. On 23/3/2011 morning, the accused Varun came to my house and in my presence told my deceased son to come with him for repayment of loan. It is not a fact accused Varun did not go to my house and that my deceased son did not go with the accused Varun on the 11th date and
cross examination is the witness wrong and you come to also the cross examination of PW 12 page number 86 se bishay kochi kichi bahar nahi come to cross examination page 86
the accused had taken loan of 10,000 from my deceased brother eta sister kochi for the marriage of his daughter, his sister, and the said fact was known to me and my parents, as well as the parents of the accused.
Cross examination, there is nothing to demolish the evidence of these two witnesses on this circumstance number 2. Now you come to the circumstance number 3. 2 and 3. এইটা তো একা জিনিস সে 2 and 3 সে গলে ଯୋଉ ଇଏରେ
ତାପରେ
ଲୋନ ପାଇଁ ନେଇକି ଗଲେ ସୋ ଆଚ୍ଛା circumstance number 3 ର discussion କୁ ଆସନ୍ତୁ page number internal page ହଉଛି 14 ସେଇ ଦିଟା witness କୁ discussion ହେଇଛି internal page 14 paragraph number 12
running page 16
running page hଉଛି 16 paile circumstance number 3
My lord.
ପଢନ୍ତୁ
On the morning of the date of occurrence, the accused had been to the house of the deceased and called the deceased to go with him to the house of his aunt for a repayment of the loan, and both of them left the house of the deceased together. To provide this circumstantial, the prosecution solely relies on the evidence of 12 and 16. They have stated in their evidence on 23/3/2011 morning in the accused had been to their house and called the deceased to repay the loan amount to 10,000 which he had taken earlier, and asked him to accompany him to the house of his aunt, and accordingly the deceased went with the accused, and on the same day in the afternoon they heard that the accused had murdered the deceased at Kanpur Hillock body. I have already discussed above in the preceding paragraph that the defense has failed to bring out anything in the cross-examination of both PW 12 and 16 as to why they would depose falsely against the accused. Therefore, this court comes to a conclusion that the accused had taken a loan of 10,000 from the deceased earlier, and on the date of occurrence morning, the accused had been to the house of the deceased and called him to accompany him for repayment of the loan, and left the house of the deceased together.
Okay, that we have seen. Now you come to the next circumstance. Circumstance number 4.
My lord. On the
What was
same day,
Hmm.
at about 12:30 p.m., the accused and the deceased were last seen together towards Kanpur Hill.
ये से भोजी वाला पढ़ंतु.
To substantiate these circumstances, the prosecution mainly relies on the evidence of PW 7, 10, 11, and 14, who are friends and were on a picnic at Suna Khainal, situated
En route. Situated en route to Kanarpur.
Hillock, after the 4 witnesses giving a unique evidence.
Unique evidence.
Unique evidence have stated that on 23/3/2011, while they were enjoying picnic at Sunakhai Now during daytime at about 12 noon, they saw the accused and deceased were proceeding towards Kanpur Hillock, and at about 2 p.m. they noticed the accused returning alone through the spot, covering his head by a Turkish towel, having an airbag in his hand. In the cross-examination by defense, except suggestion that they were not enjoying picnic near Sunakhainal, date of occurrence, and they have not seen accused, the deceased going together towards Kanpur Hillock, nothing material was brought out from them to discard their testimony. Relying on the evidence of PW 7, 10, 11, and 14, the learned public prosecutor submitted that the prosecution has successfully proved through these witnesses the circumstance that the accused and the deceased were last seen together going towards Kanpur Hillock by side of the Sunakhai Nal. The learned SDC, criticizing the evidence PW 7, 10, 11, and 14, submitted that the conduct of the witness is doubtful and not accordance with the normal human conduct, since they had been to Sunakhainal for specific purpose, picnic, and had no occasion to pay their attention to the passerby going through the nearby road. He further argued that even for the sake of argument, if at all the last seen theory is accepted, law mandates that last seen theory came into play where the time gap between the point of time where the accused and the deceased were last seen alive and when the deceased was found dead is so small, the possibility of any other person other than the accused is the author of the crime becomes impossible. On an analysis of evidence of PW 7, 10, 11, and 14, it appears that all of them have stated that on the date of occurrence at noon, while they were enjoying picnic at Sunakhainal during daytime at about 12 noon, they saw the accused and the deceased were proceeding towards Kanpur Hillock, and about 2 p.m. they noticed the accused returning alone through the spot, covering his head by a Turkish towel, having an airbag in his hand. In their cross-examination, the defense also failed to rebut their evidence, and their evidence remains unshaken throughout that they saw the accused and the deceased going together on the date of occurrence at 12 noon towards Kanpur Hill. With regard to the submission made by the learned ASDC about the conduct of the witnesses PW 7, 10, 11, and 14, I am of the opinion that the conduct of any witness cannot be presumed to be contrary to the normal human conduct. And this contest, the Honorable Supreme Court in Apabhai and another versus State of Gujarat reported AR 1988, Supreme Court held that court cannot reject the evidence of witness merely because they behave and react in an unnatural manner. There is no dispute with regard to the proposition of law as submitted by the learned SDC that the last seen theory came into play, where the time gap between the point of time when the accused and the deceased were seen last alive and when the deceased was found dead, it is small. But in case at hand, there is positive evidence that all these witnesses had seen the accused going with the deceased at 12 noon, returning alone about 2:30 p.m. and immediately thereafter the dead body of the deceased was found on the hilltop. In this case, the time gap is not so long as to defeat or frustrate the version of the prosecution. Therefore, there can be no trace of doubt that the deceased was not last seen in the company of the accused. Consequently, the submission of the learned SDG that the possibility of any other person other than the accused is the author of the crime has no force.
So, आज गोटी evidence ए 4 जन जाके एका evidence अछि. You come to the evidence of PW7, then we'll know your comments on this witness. PW7 person, ये के होची informant. Page number 71, paper book.
सेवन से जो फ्रेंड ये बोधी करती 7
हाँ पर
अपरा
informant हाँ.
नहीं इन्फॉर्मेटिव 14
वो अच्छा हाँ सी एक कवड़े evidence थी वो तो
आगे
let us see that 7%.
Page 77.
71
Page 71. Prosecution is
Read, I know the informant. Dandapani Dve.
my name is Nishakar Pradhan.
Oh, paragraph 1 to Poduntu. Nishakar Bhera.
I am know the informant.
I am.
I know the informant. Dandapani Behera.
Informant is PW14 though. PW14.
I also know the accused as well as the deceased. On the 23/3/2011, I, along with my friends, namely Dandapani Behera, Sushant Rusti, Babuli Sahoo, was enjoying picnic at Sunakhaina during daytime. While we were enjoying picnic at about 12 noon, we saw the accused and the deceased were proceeding towards Kanpur Hillock at about 2 p.m. The accused alone returned back through the spot covering his head by Turkish towel, having an airbag in his hand. We doubted some foul play and asked the accused but the accused did not give any reply. We also found the wearing apparels of the accused were stained with blood and also injury on his left thumb. Then we threatened him to call police. Hearing the name of police, the accused stated before me and others that he had taken 10,000 as loan from the deceased, and when the deceased asked for a repayment of the loan, he planned to murder the deceased. Accordingly, accused took the deceased to Kanpur Hillock and murdered him by means of a sharp knife by cutting his throat, and thereafter burnt the dead body by collecting dried leaves. Hearing this from the accused, I informed one Kunja Bihari Sahoo, PW4, over telephone, and after arrival of Kunja Bihari Sahoo, the accused disclosed his name before Kunja Bihari Sahoo as Varun Behera of village Chitalpur and confessed to have murdered one Pintu alias Priyavrati Pati. Thereafter, I, along with others, and Kunja Bihari Sahoo and the accused went to the hilltop. The accused led us to the spot where he threw the dead body, and on our arrival at the spot, we found the dead body was already burnt by 3/4, and also there were injuries on the neck of the accused. Then we all, including the accused, climbed down from the hillock Kunja Bihari, Sahoo PW4 informed the police about the occurrence. MOI is MO1 is the shirt which the accused was wearing on the day of the occurrence, having blood stains on it. Cross examination. 23/3/2011 was not a festive occasion. Sushanta, Babuli and Dandapani are the owners of the tractor and I was the driver of Babuli Sahoo. It is a fact that there is a stone quarry near Sunakhaina and laborers were working throughout the year in the quarry. Distance between my village and Kanpur Hillock will be about 6 kilometers. Village Indupur situates between my village and Kanpur Hillock. The distance between the place where we are enjoying picnic and the spot where murder was committed is
About 1 kilometer.
About 1 kilometer. There is another path road from village Kanpur to Kanpur Hillock. The place where we were enjoying picnic was having 1 or 2 cashew trees. There is a Harijana Basti, locally known as Juangasahi, situated 1.5 kilometers away from the picnic spot. I had no prior acquaintance with either accused or deceased. The witness identified the accused, standing in the dock. It is a fact that I have not stated to the police that thereafter injury on the left thumb of the accused. It is not the accused did not confess before me and others that he committed murder of the deceased and that I am deposing falsehood.
What is your comments on this witness? He is a witness who, along with the other witnesses, like the informant and others, they were organizing a feast, and they saw the accused and the deceased passing, and them at about 12 noon. Again, appellant returning alone, and he was covering the top his towel and holding an airbag, so doubted something, and they also saw the wearing apparel stained with blood. And when threat was given, he disclosed that for this 10,000 he has committed the murder, and also for the throat and burnt. Then he led the persons to that place and showed the dead body, and that was found to have burnt by 3/4, and injuries were found on the neck. So he has also identified the shirt which the accused was wearing, which was having that blood stain. So
Why these people will be disbelieved?
this statement must have also been stated by the other witnesses. ଏ ଯୋଉ ତା ସାଙ୍ଗରେ ଯୋଉମାନେ ଭୋଜି କରୁଥିଲେ ସେମାନେ ସେଇ ଟାଇପର କହିଥିବେ ନା ନାଇଁ କହିନାହାନ୍ତି? ଆପଣଙ୍କର ଇନଫର୍ମାଣ୍ଟ ମଧ୍ୟ କହିଥିବ PW14 କହିନି PW14 କୁ ପଳେଇ ଆସୁନାହାନ୍ତି, ପେଜ 91 ଦେଖନ୍ତୁ।
Same.
ଯୋଉ ଭୋଜି କଥା, 2 ଜଣ ଗଲେ, ଜଣେ ଫେରିଲା, ତାର ଏମିତି ରକ୍ତ ଲାଗିଥିଲା, ତାକୁ ପଚାରିଲେ, ସିଏ କହିଲା ଏଇଆ, ତାପରେ ଏଗୁଡା ପଚାରିଲେ
covering his head.
page 91 କୁ ଆସନ୍ତୁ, ପଢନ୍ତୁ।
I am the informant on this case. I know the accused standing in the dock. I also knew the deceased Pintu Priyavrata Pati. On 23/3/2011, I, along with my friends, namely Sushant Prusti, Babuli Sahoo, Nishakar
जोटा अभी just पढ़िले
P7.
and Jitu Nishakar होती driver.
ସେ P7.
P7
Aye,
second.
and Jitu Sahu and others we are enjoying picnic at the Sunakhai Nala. During daytime, while we were enjoying picnic at about 12:30 noon, we saw the accused and the deceased proceeding towards Kanpur Hillock by walk at about 2:30 p.m. The accused alone returned back through our picnic spot, covering his head with a Turkish towel, holding an airbag in his hand. We doubted some foul play as we found that the blood stains on his wearing apparels. He remained silent, and when we threatened to call police, he disclosed before me and others that his name is Varun Behra and the name of the person accompanying him, Pintu alias Priyavratapati, and that he had murdered that Priyavratapati by means of a sharp cutting knife by cutting his throat on the hillock. Hearing this from the accused, we informed Kunja Bihari Sahu of village Hindupur, who advised us to
Detain the accused.
And after arrival of Kunja and the police, we all went to hilltop with the accused, and thereafter the accused led us to the place where he had thrown the dead body of the deceased and
Set him on fire.
And on arrival at the place, we found the deceased was laying dead, facing towards having
Facing downward,
burn injuries, and also we found there was cut injuries on his neck. Thereafter lodged a report before the police regarding the incident. This is my report marked as Exhibit 12, and Exhibit 12(1) is my signature thereon, cross-examination. It is a fact that there is a stone quarry near Sunakhai. It is also a fact that there was a Chuanga Sahi near the Nara. It is a fact that there is only one road which leads to the village Kanpur to Hillock. That the place where the dead body was laying is not visible from the place where we are enjoying picnic. The distance between the place of a picnic and the place the dead body was laying is about 1 kilometer. The distance between the place where we were enjoying picnic and the place where we saw the accused and the deceased going together is around 8 kilometers. I had no prior acquaintance with either the accused or we five, namely myself, Babali Sahu, Sushant Prushti, Jitu Sahu, and Nishakar Pradhan, we are enjoying picnic on that irrelevant day. Our friend, namely Sushant Prushti, called the accused at the first instance when he was returning from Hillock alone. It is a fact that we detained the accused as per the advice of the Kunja. It is also a fact that we tied the hands of the accused with a napkin, gamucha. Kunja Bihari Sahu also accompanied us to the Hillock. The accused was under the custody of the police when he led us and police to the place where he had thrown the dead body of the deceased after setting it on fire. I was examined by police the spot itself. It is a fact that I have not stated before the police that the accused had covered his head with a Turkish towel, holding an airbag in his hand. It is not a fact that where I have deposed in the eyewitness all are false. I was examined by the police at the spot It is a fact that I have not stated before the police that the accused had covered his head with a Turkish towel holding an airbag in his hand. A contradictory statement, my lord. I was examined by the police. It is a fact that I have not stated before the police. Police agare कहनी.
कोटा
कहनी that the accused had covered his head with a Turkish towel holding an airbag in his hand.
এটা কহিনি কোন হলা তাহলে অবি সেটা কহিনি পুলিশ
Consequence
বর্তমান
কଣ?
রে কହୁଛି which is corroborated by the other evidence that in fact when he was returning he had covered say evidence of the PW7 ଅଛି ନା
710
ନାଇଁ ଜଷ୍ଟ ଆମେ ଯାହା ପଢିଲୁ ଏପର୍ଯ୍ୟନ୍ତ 7 ବି କହୁଛନ୍ତି ତେଣୁ ଧର ଏଇ ଷ୍ଟେଟମେଣ୍ଟଟା ସେ କହୁନି ପୋଲିସ ପାଖରେ କହିନି ଆସି କୋର୍ଟରେ କହିଛି ବଟ୍
Is it something new that others have also not told, but he has told in the court?
and it appears from the and perhaps the
All through
police
consistent.
also reached at the spot କାରଣ ଏଭିଡେନ୍ସ ହଉଛି ଷ୍ଟେସନ ଡାଏରୀ ଏଣ୍ଟ୍ରି କରିକି ପୋଲିସ ପଳେଇ ଆସିଥିଲା
The information.
ତାପରେ ପୋଲିସ ବି ରହିଛି କାରଣ ଏଇ ଯୋଉ ଅକରେନ୍ସ ଟା ବି
କୁଞ୍ଜ ବିହାରୀ
କୋର୍ଟଟା ଦିଆଯାଇଛି ସ୍ପଟ ରେ ଦିଆଯାଇଛି ଲେଖା ହେଇଛି
PW4 ପଏଣ୍ଟିମରେ କୁଞ୍ଜ ବିହାରୀ arrived along with the police.
ହଁ ସେଠି ଲେଖା ହେଇଛି ଆଜି 23 ସୁଆଣରେ କଅଁରପୁର ଗ୍ରାମ ନିକଟବର୍ତ୍ତୀ ରଗଡା ନିକଟରେ ଆପଣଙ୍କୁ ଲିଖିତ ରିପୋର୍ଟ କରିବି ଏବଂ ପୋଲିସ ମଧ୍ୟ କହୁଛି PW କେତେ ସେ
70
ଆଇଓ ଟା କେତେ
70
17
ମାଇଲ page 90
ସିଏ ବୋଧେ କହୁଛି ଯେ ମୁଁ ଷ୍ଟେସନ ଡାଏରୀ ଏଣ୍ଟ୍ରି କରି ପଳେଇ ଆଇଲି ହଁ ଠିକ ତ PW 17 I was working IIC on that day during afternoon I received a telephone call the dead body was so and so getting information I proceeded so and so after making SDN and reached the spot and on the spot I received the written delivery. तो ଏଇ ଯୋଉ ଏଭିଡେନ୍ସ ଟା ଆପଣଙ୍କର ଏଗେନଷ୍ଟ ରେ ଚାରିଟା ସାକ୍ଷୀ କହୁଛନ୍ତି ଆପଣଙ୍କୁ କ୍ୱେଶ୍ଚିନ୍ ପଚରା ହେଇଛି ଆ ଉପରେ ଆପଣ ମିଛ କଥା କହିଛନ୍ତି ଯେ ନାଇଁ ବଟ୍ वी हैव read this two at least 7 and 14 and there are also the evidence of another two witnesses that is 10 and 11 ठीक तो मिस्टर महांती 10 और 11 ମଧ୍ୟ ସେ ବିଷୟରେ କହିଛନ୍ତି
ଜିତୁ ଅଛି ଆଉ
10
ବାବୁଲା
same evidence we are holding picnic going there
रात 10 11
returning 2 p.m covering the body
14 भी से 14 और
14 का
ପଢି ଦେଲୁ
ନାଇଁ 10 ଆଉ 11
7 10 11 14 they all have corroborated each other.
11 भी शेयर कोचिंग enjoying the picnic found accused and deceased proceeding 2:30 रे accused एग्लन फेरला कवर करथिला तापरे doubted foul play तापरे ताकू अटकेलु wearing apparel stained with blood then he disclosed have committed the murders by putting so and so. तो ये जो circumstance टा अपन वर्तमान तारीख पे जो पढ़िले evidence that is circumstance number 5 4 and 5 12:30 रे accused and deceased were last seen going together towards Conro Hill and 2:30 रे अपन एकुटिया पेरिले covering your face with a Turkish towel and your stained with blood and you are having an airbag এবং circumstance number 6 made extrajudicial confession before so and so to have murdered the deceased, burnt the body and you are detained and police was informed and after the arrival of the police FIR lodged. So you 4 5 ଆଉ 6 ଏ ତିନିଟା circumstance ଉପରେ ଏଇ ଚାରିଟା ସାକ୍ଷୀ ହିଁ ହଉଛନ୍ତି relevant 7 10 11 ଆଉ ତ what are your comments? Because we have seen the analysis of the Lennon trial court on circumstance number 4 and come to
5.
circumstance number 5 also. You come to page number 18, author number paragraph question, page 18, author number page ko. Internal page 18, running page 20, paragraph number 14. Circumstance number 5 ta discuss is. Paile 14 number paragraph. Page number 8, 18 hochi internal page, running page hochi 48.
My lord,
Circumstance number 5.
on the same day,
Padam.
at about 2:30 p.m., the accused was seen alone, returning back, having covered his face by a Turkish towel with blood-stained cloths and having an airbag. To substantiate the circumstance, the prosecution has also relied upon evidence PW 7, 10, 11, and 14. All 4 witnesses have stated that 23/3/2011, while they were enjoying picnic at Sunakhainal during daytime and alone at about 12 noon, they saw the accused and the deceased were proceeding towards Kanpur Hillock at about 2:30 p.m. They noticed the accused returning alone through the spot, covering his head by a Turkish towel, having an airbag in his hand. They also noticed blood stain on his wearing apparels. So, doubting the accused, they asked the accused about the blood stains on his wearing apparel. Although first the accused remained silent, but when they threatened him to call police, he confessed to have killed the deceased by cutting his throat by means of a sharp knife at Kanpur Hillock and burnt the dead body. This part of evidence PW 7, 10, 11, and 14 also remains unshaken in the cross-examination by the defense. Relying on the evidence of PW 7, 10, 11, 14, the learned public prosecutor submitted that the prosecution has successfully proved through these witnesses that the accused, after killing the deceased and burning the dead body, was seen coming along by the side of the picnic spot, covering his head by Turkish towel, having an airbag in his hand. For contrast, the learned ASDC submitted that had the accused committed the murder of the deceased, he would not have returned through the same path, so as to be caught red-handed by the aforesaid witness, which is highly improbable, and therefore this circumstance is not proved by the prosecution on contest of accused with the alleged crime. So evidence PW 7, 10, 11, and 14, it appears that while they were at picnic spot on the same day at about 2:30 p.m., the accused returned through the same path by covering his face by his Turkish towel, holding an airbag in his hand. They also noticed blood stains on his wearing apparels. So, doubting the accused, they asked him about the blood stain on the wearing apparels. Although first the accused remained silent, but when they threatened him to call the police, he confessed to have killed the deceased by cutting his throat by means of Sonam knife, Kanpur Hillock, and burnt the dead body. In cross-examination, PW has stated that there is only one path which leads to the village Kanpur to Hillock, near which PW 7, 10, 11, and 14 were enjoying picnic. So presumably, it can say that the accused had no other way to return back from the Hillock after committing murder than this picnic spot. So it is my view, the prosecution is said to have proved the circumstantial evidence against the accused beyond doubt.
How do you challenge the evidence of these 4 witnesses on this?
My lord, these all are the circumstantial evidence. My lord, apart convicted under sentence, prosecution case is based on circumstantial evidence extrajudicial confession in the village meeting village. So my lord, these circumstances leading to discovery of the dead body of deceased at the instant.
आउडे पढ़ुଛନ୍ତି आउडे केस ना कोन
My lord,
अरे विलेज मीटिंग कोठा हैला
ना village meeting रा ये जो केस टा ना एटा जो circumstantial evidence
एक केस टा हम पचार एक केस रे कोन पई से जो चार जण साक्षी को डिसबिलीव हो आपण विलेज मीटिंग आडे कोड गले
ना my lord,
जजमेंट प्लीज
ओ जजमेंट अछि हां ए केस टा रे चारि जण साक्षी जो माने की भोजी करूथे आपण दी जण को बार देखिले प्राय 12:30 हेइतला 2 घंटा परे तादुर जणे फेरिला आ से जण को होचंती अक्यूज घोड़ी गाड़ी हेकिनी फेरुथाय गोटे एयर बैग धरथाय एवं से माने तर संदेह हला ताको अटकेइले तापर देखिले तारो ब्लड स्टेन रहिछि तार वेयरिंग अपैरल्स तेणु आउरी संदेह हला ताको पचरा पचरी कला परे सी कहिला जे मु ताको एठी मर्डर करछि तार तंटी काटी देछि एवं ताको पोड़ी मध्य देछि तापर ताको डिटेन करले खबर देले पुलिस आसिला एवं जो डेड बॉडी टा रिकवरी हला ए जो एविडेंस ए जो आसीछि चारटा इयरु एटा गोटे हला लास्ट सीन गोटे हला आपनकर एक्स्ट्रा जुडिशियल कन्फेशन गोटे हला आपनकर वेयरिंग अपैरल्स ब्लड स्टेन देखिवा हला ए जो
तांको पाखै करता से पुलिस सीज करछि सब से बैग
एयर बैग
पर्स
एयर बैग गुडा
डिसीज
हां जोड़ा डिटेन कर रखथिले तो ये एविडेंस जो चार जनकर कोन पई डिसबिलीव हबो एक्स्ट्रा जुडिशियल कन्फेशन
my lord,
अरे एक्स्ट्रा जुडिशियल
My lord-
कन्फेशन विषय कम से कम तो कहूँ
हाँ extrajudicial confession leading to discovery
Extrajudicial confession re, why it is to be taken as extrajudicial confession?
because
Because
they have he has confessed before not before the magistrate.
मजिस्ट्रेट पाते है जुडिशियल कन्फेशन
एटा
extrajudicial
extrajudicial एटा चेन
एक्स्ट्रा जुडिशियल कन्फेशन रो प्रिंसिपल कोन कोठी एक्सेप्ट हबो एक्स्ट्रा जुडिशियल कन्फेशन को सेक्शन रे एक्स्ट्रा जुडिशियल कन्फेशन टा रिलेवेंट वे
my lord
Evidence
section
act
24
24
my lord
एक्स्ट्रा जुडिशियल कन्फेशन एक्सेप्ट करियो को हेले कोर्ट
कौन-
कोन प्रिकॉशन दरकार कोर्ट कोन देखिले जायगी नी एक्स्ट्रा कन्फेशन एक्सेप्ट करियो जे कन्फेशन टा को टाइप रो हवा दरकार एठी सेटा रहिछि ना ता देरे किछि व्यतिक्रम आपण देखुछन सेक्शन 24 अच्छी आपण पाखे एविडेंस एक्ट
I will satisfy my lord दी दिन पर एटा आसु चारिटा आ सेटा extrajudicial confession ingredients एटा टिके to be more
आपण मेंशन करिकिन आइटम नंबर 54 पूरा रेडी हिकिना
ready जे my lord ए जो कोरी my lord has
this is literal.
my lord मु कहूचे एटा extrajudicial jurisdiction it cannot be accepted
काहे की
because of the entire case based upon a circumstantial evidence.
After you were talking of a extrajudicial confession and now you are taking it to the circumstantial evidence. The entire case is circumstantial evidence. And one of the ingredient is this. One of the circumstances is extrajudicial confession. So why this extrajudicial confession made by the accused in presence of or before the witnesses 7, 11, 12, 14.
ମୁଁ କହୁଛି extrajudicial jurisdiction କାହିଁ କହୁଛି appellant before the informant confession before the informant his friend and leading to discovery of the weapon of the offense is not maintainable in the appellant.
କାହିଁକି
କାହିଁକି କହୁନାହାନ୍ତି ଆମେ ତ କାରଣ ପଚାରୁ ଆପଣଙ୍କ ନଟ୍ ମେଣ୍ଟେନେବୁଲ ଆରେ କଣ କାରଣଟା କୁହନ୍ତୁ ଚାରିଟା ସାକ୍ଷୀ କହୁଛନ୍ତି ଏକ୍ସଟ୍ରା ଆମେ ଆପଣଙ୍କୁ ସେ ବହୁତ ଜିନିଷ କହିଛନ୍ତି ଆମେ ଆପଣଙ୍କୁ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ବିଷୟରେ ହିଁ ପଚାରୁଛୁ ଯେ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ଯୋଉ ଚାରି ଜଣ କହିଛନ୍ତି ଯେ ଆସିକିନି ଆମ ପାଖରେ ଦୋଷ ସ୍ୱୀକାର କଲା ଏବଂ ଏଇଆ କହିଲା ମୁଁ ମାରିଛି ଛୁରୀରେ ମାରିଛି ଏବଂ ତାକୁ ପୋଡ଼ି ଦେଇଛି এই স্টেটমেন্টটা কাহিকি বিলিভেবল নহব এটা এক্সট্রা জুডিশিয়াল কনফেশন হিসাবে acceptable ହବ କି ନ ହବ ଆପଣଙ୍କର ତା ଉପରେ ଚ୍ୟାଲେଞ୍ଜ କଣ?
ଆଉ 2 ଦିନ ସମୟ ଦିଅନ୍ତୁ।
ଏଇ ଜିନିଷ ଆସିଲା ପରେ ଆଗେ ଆଗେ ସେକ୍ସନ 24 ଟା ପଢିଥାନ୍ତେ,
ନା ସାର୍ ପଢିଛି ଯେ
ତାପରେ ଲ ଟା କଣ ଜାଣିଥାନ୍ତେ,
ଆଜ୍ଞା।
ତାପରେ ଏଭିଡେନ୍ସ ଟାକୁ ଦେଖିଥାନ୍ତେ, ସୂତ୍ର କିଛି ମିଳିଥାନ୍ତା।
ଆଉ 2 ଦିନ ସମୟ ଦିଅନ୍ତୁ।
ଆପଣ ଯେମିତି ପ୍ରଥମରୁ you mentioned it also in the, I think
Twice.
last twice you have mentioned.
Minor.
So we are taking this matter out of turn.
Minor.
We thought that you are fully prepared, but we don't find that you are even half prepared. What to say about fully? But it is a 302 case, life imprisonment. We will give you time, no doubt, but prepare it thoroughly.
Minor.
See the principle of extrajudicial confession. Extrajudicial confession को accept करिया गले कोर्ट रो कौन जो जिंस दरकार एथरे आपण आउ थरे माइन्यूटली पढ़िबे से जिंस गुडा अछि ना नाही किछि संदेह होउछि ए जिंस गुडा को मिस करूछि योथि पय एक्स्ट्राजुडिशियल कन्फेशन ता ग्रहणीय होबन। आ जदि एक्स्ट्राजुडिशियल कन्फेशन को आमे काटी दबु तो धरो
एविडेंस अछि
तारे एविडेंस जाटा अछि ताले से जो प्रिंसिपल टा पढ़िले जो चेन कंप्लीट हबो से चेन टा कंप्लीट होउछि कि नाही बाकी जहा अछि जदि भी एक्स्ट्राजुडिशियल कन्फेशन को आमे काटी दबु
चेन ऑफ सर्कमस्टेंस
हाँ चेन ऑफ सर्कमस्टेंस बाकी कंप्लीट होउछि ना नाही सो दैट आपणकर कम्प्लिसिटी टा आसीबो ता दिरो आछि ना नाही फास्ट आगे देखंतु एक्स्ट्राजुडिशियल कन्फेशन बिलीव हबो कि नाही ए जो जहा से माने स्टेटमेंट देइछन जो सर्कमस्टेंस रे एक्स्ट्राजुडिशियल कन्फेशन टा हेइछि हला धरिले कहले पुलिस पाखरे को धमक चमक देले तापरे कन्फेशन टा आइछि एटा बिलीवेबल हबो कि नाही एक्स्ट्राजुडिशियल कन्फेशन रो नीति नियम टा कोन एक्सेप्ट करिया गले तापरे आपण एनालिसिस करिए हला तो हमें नेक्स्ट सिटिंग होछि मंगलवार दिन तो मंगलवार दिन रखुछु ताकू प्रिपेयर हेकि आसु फुली प्रिपेयर आसु हला आडिंग पार्ट कर देगी डॉक्टर
जो माने हियरिंग का टॉप का आस्ता सुदर्शन
हां सिंपल
सॉरी जी पे
टॉप पे कर दो पार्ट मैटर तो आउट रहिछि पा से जोटा
एटा खाली 3 नोटा मु दे
हां नहीं आमे ताको आनु
आगे
पाठ देगी ना
एक दूरे पळे
एक दूर आसीबो तो आप